Welcome to Philosophy 3142W at the George Washington University. I'm Dr. Jeffrey Brand, your instructor. When I'm not stuck in this little box in the corner of the screen, I'm an associate professor in the Department of Philosophy, where I've worked since 2002. Today I'm going to introduce the subject matter of the course. You can learn about the course requirements in the orientation section of Blackboard. This course is a general introduction to the philosophy of law. It aims for breadth rather than depth. The subject goes by many names, including jurisprudence, legal theory, and legal philosophy. Legal philosophy is somewhat peripheral to the field of philosophy as a whole, but it's broad nevertheless. I've had to make difficult decisions about what to include in this basic course. I've chosen to concentrate on topics that occupy two interrelated groups of scholars: professional analytical philosophers who write about law, and legal scholars who study these philosophers and are studied by them. Giving the course this focus aligns it with what's widely considered the mainstream of legal philosophy in the English-speaking world. Within this set of topics, I emphasize those that are accessible to undergraduates and least likely to be covered in other courses. I also give preference to topics encountered by law students and topics that interest law professors, as opposed to historians, social scientists, or philosophers whose primary specialization is something other than legal philosophy. This course doesn't presuppose any knowledge of philosophy. It assumes that you know what the typical North American college student knows about legal systems in the USA. Philosophers will quickly recognize this course as emerging from the analytical tradition rather than the continental European tradition of Hegel, Marx, Heidegger, Merleau-Ponty, and Derrida. Some legal philosophers writing in English draw from the continental tradition. They ask some of the same questions posed in this course, although most of their questions are quite different. There's been little interaction, unfortunately, between continental legal philosophers and the scholars in this course. This course also contains little discussion of feminist jurisprudence, critical race theory, or queer theory, although these are major schools of thought, which I readily classify as legal philosophy in a broader sense. Each deserves its own introduction. Many of the questions posed by these critical scholars are questions of normative jurisprudence. Critical scholars examine ways in which actual laws and ideas about law work to perpetuate the subordination of women, people of color, lesbians, gay men, and others. Critical scholars develop new ways of thinking about law. They challenge the status quo and advocate for law reform. Unfortunately, there's been little dialogue between critical scholars and the community of scholars on whom I've chosen to focus. Bridges should be built between these groups, and they are being built, but critical scholarship still represents a separate intellectual tradition from the one I introduce in this course. I believe that legal philosophy has improved substantially in the past 50 years, and it's more sophisticated today than it's ever been. I also think that undergraduates benefit from exposure to the most recent work, even without a foundation in the history of philosophy. This course emphasizes the past 5 decades. This is not to understate the importance of Plato, Aquinas, Hobbes, Blackstone, Kant, or Bentham. Undergraduates sometimes ask me if studying legal philosophy will help them in law school. This is an empirical question that no empirical studies addressed, so I don't know the answer. My suspicion, which has no scientific basis, is that studying legal philosophy probably has some value as preparation for law school. Consider the following statement from the Department of Philosophy at New York University. Philosophy has a special affinity with the legal profession, in which argument and the application of general rules to cases play central roles. Many law schools recognize this connection and are especially receptive to philosophy majors. Justices Breyer and Souter of the U.S. Supreme Court were both philosophy majors in college. I'm not sure what that proves. Students of mine who've gone on to study law sometimes report that my courses helped them as law students. Maybe they're just being nice. A better question would be, is there another liberal arts course that would be more helpful to a law student than legal philosophy? Maybe not. Legal philosophy might be as good as it gets for pre-law students. Whatever the preparatory value of legal philosophy, the best reason to study the subject is that you find it intrinsically interesting. Learning legal philosophy makes studying law more interesting too. I hope that's enough for you. Well, what is philosophy? Here's a tentative definition. It's the systematic study of arguments concerning the most general and fundamental issues. The philosophy of something is a subdiscipline addressing the general and fundamental issues that arise in that domain. Western philosophy, which is what we're going to do, has some characteristic features. It's methodical. It uses reasoning and logic. It's a quest for good reasons or justifications for thought and action. It demands open-mindedness. It requires careful, repeated reading. It involves creative exegesis. But it requires original thought, not just repeating the ideas of others. We can divide legal philosophy into three main divisions: analytical jurisprudence, descriptive jurisprudence, and normative jurisprudence. Analytical jurisprudence asks conceptual and metaphysical questions. What's the nature of law? What is law? What kind of thing is it? What makes something law instead of being something else? If law is real, what's it made of? What does it mean to say that certain conduct is illegal, or breaks the law, or violates the law, or is against the law, or exposes you to legal liability? Where does law come from? What are the sources of law? How do you determine what the law is or says about something? Analytical jurisprudence also studies the implications of law, meaning what necessarily follows from the fact that something is law. What's the relationship between law and human behavior? What's the relationship between law and morality, ethics, or justice? What's a legal obligation? When's it okay to break the law? Is there such a thing as an unjust law? How should we interpret legal documents like statutes, judicial opinions, and constitutions? Descriptive jurisprudence examines actual laws and legal systems and offers general accounts of them. For example, a scholar might examine the 19th century Japanese law of inheritance and try to determine what general values, ideas, and principles it reflects. We'll do a little descriptive jurisprudence in this course, but not much. Normative jurisprudence concerns what the content of the law ought to be from the perspective of a conscientious lawmaker. Normative jurisprudence evaluates existing laws and prescribes revisions. How should the legal system operate? What standards should govern the conduct of legal actors? How much power should the government have to regulate the conduct of citizens by means of the law? What kinds of conduct should the law regulate? Getting more specific, normative jurisprudence asks questions about topics like punishment. On what basis should the type and amount of legal punishment be determined? Should death be the punishment for some crimes? How should the law regulate sexual conduct? How about abortions? What should you have the legal right to say and when? Should the law tell you how to run your own company? What kinds of lawsuits should be allowed? What standards should govern the discovery, admissibility, and relevance of evidence in the courtroom? These are some questions of normative jurisprudence, but there are more of these questions than there are laws, real or imagined. This course pursues many goals simultaneously. I want you to learn to read and interpret legal philosophical arguments, to understand the structure of debates and the character of theoretical disagreement, to ask hard questions about familiar topics, to recognize invalid and fallacious arguments, to draw out your implicit philosophical views, to explore how well your worldview holds together, to appreciate the merits of opposing viewpoints, to begin to develop positions in legal philosophy, to defend your own views against criticism, and to express yourself with precision, economy, and a little style. That's a lot to expect of you, but I'll do my best to make the process enjoyable. Let's get started.